On September 1st of 2021, there were amendments that were passed through the Texas legislature concerning 87 RHB 3115. Now, this specific proceeding commenced prior to September 1st of 2021. Actually, the first formal notice is dated for July 12th of 2021. By the way, July 12th of 2021 is exactly 2 years after the date on my birth certificate. I have already alerted numerous people to how there was fraud involved with the acquisition of my replacement birth certificate, specifically because I had put a money order with the attempt to get my long form birth certificate from my birth state. And the individuals that received the request for my long form birth certificate claimed they never received payment. I have all of the information I need regarding my allegations that there was fraud involved with my primary identification document and the fact that they intended to date their alleged eviction notice on the 2 year anniversary of my birth certificate, while they also made sure to postmark it for what was the date of issuance on a 30-year bond that itself was a reissue from a previous bond. I contend is absolutely 100% an act of securities fraud, up to and including the highest level. The fact that they then attempted again to date another fraudulent service and notice for August 12th, 2021, which was the date of settlement on a large scale municipal bond, or rather, a large scale security for Kennebunkport, is again another act of large scale securities fraud, intentionally and willfully engaged just as such. I do not consider this in any way, shape, or form to be a derivative process. With that said, because of the fact that this proceeding was commenced before the changes took effect on September 1st of 2021, then the law prior to September 1st, 2021 would be the one of concern. I'm going to quote from the HB 3115 concerning the elements of the Texas Homestead Code. B. A judgment debtor may file in the real property records of the county in which the judgment debtor's homestead is located. Then additions, as of September 1st, say, quote, 1. An affidavit that has more context to it. 2. A certificate of mailing, end quote. Now, in the original, the certificate of mailing was not a requirement. And the affidavit, in the context of the affidavit, was different. These were added as of September 1st. My understanding is what they were doing was attempting to simulate something that would have been covered after the September 1st changes. But because they commenced the proceeding prior to September 1st, it is under the actual law as it was at the time the proceedings commenced. And that means that, as it says, and it's said in the law, it was added into the law here. If a judgment debtor has filed a certificate of mailing under subsection B and a contradicting affidavit is not filed under subsection E, then what the law was before. A bona fide purchaser or mortgagee for value, or a successor or assign of a bona fide purchaser or mortgagee for value may rely conclusively on an affidavit filed under subsection B. Then, another addition. For the 90-day period that begins on the 31st day after the date the certificate of mailing was filed. Now, according to the law prior to September 1st, the only things that were applicable were B. A judgment debtor may file in the real property records of the county in which the judgment debtor's homestead is located. And then D. A bona fide purchaser or mortgagee for value, or a successor or assign of bona fide purchaser or mortgagee for value may rely conclusively on an affidavit filed under subsection B. Under the Texas Business Organizations Code, section 101.451, managing entity, and under section 101.453, demand, A member may not institute a derivative proceeding until after the 91st day after the date a written demand is filed with the limited liability company, stating with Particularity, the act, omission, or other matter that is the subject of the claim or challenge, and requesting that the limited liability company take a suitable action. B, the working period required by subsection A before a derivative proceeding may be instituted is not required, or if applicable, shall terminate if 1. The member has been notified that the demand has been rejected by the limited liability company. 2. The limited liability company is suffering irreparable injury. Or 3. Irreparable injury to the limited liability company could result by waiting for the expiration of the 90-day period. This law was originally implemented on January 1st of 2006. The most recent update was on September 1st of 2019. That means the entire time that I have been incorporated as an LLC, this law has been in effect. It also means, and states very succinctly, that in order for any derivative action to commence, there must be a formal notification, including an explication of the terms under which that derivative action is to be engaged, and it cannot commence until the 91st day after the formal notice is served, and there are conditions under which it can be declined, and that is what the law says. Section 16, Bills of Attainder, Section 16 of the Bill of Rights of the Texas Constitution, Bills of Attainder ex post facto or retroactive law, impairing obligation to contract. No bill of attainder or ex post facto law, retroactive law, or any law impairing the obligation of contracts shall be made. I contend any efforts to treat this as if it was applicable under the laws that went into effect on September 1st of 2021 constitute a retroactive law and hence have no constitutional validity. If there is to be any process that is commenced, it must follow the law as it was at the time. If they seek to, after what happened thus far, to engage in an appeal, then they would have to do it under the current law, which means that they would have to have a 90-day period that begins on the 31st day after the date of certificate of mailing was filed. That means they are not within the appropriate period. Why? Because, as I will explicate in here, I have not seen a lease, I have not seen a mortgage, I have not seen a trust agreement, I have not seen a utility bill, I have absolutely no proof of who actually thinks that they're entitled to say that they're the mortgagor or the owner of this place. And until I do, they have no legal claim. This is not a lease. This is not a tenant at sufferance, or, which they could alternatively call it, a tenant at will. I contend there is a specific distinction in terms of the characterization they were seeking by identifying it as tenant at sufferance as opposed to tenant at will. And it also puts a different burden of proof on them that they classified it in such a manner. There is indeed irreparable harm that is to be done insofar as they've engaged in illegal derivative action, and it has had a material impact on not only my capacity to provide for myself, not only the fact that they have refused up until they engaged this proceeding in the manner they did that is demonstrably connected to other acts of securities fraud about which at least the major person of concern had already been apprised and numerous agencies have been alerted to, but also because in the course of this, there have been other derivative actions that have had a material harm visited upon me personally and also upon my LLC and others that were connected to those acts that had occurred. I provided written confirmation of my understanding in January 2020, as is attested in my affidavit, that I understood that this was a homestead situation. I have the evidence of that as necessary. It's also referenced and specifically explicated in the affidavit, which I will not be reading. I filed my affidavit with one consideration in accordance with understanding this proceeding to be unlawful and in the wrong jurisdiction through intent. In other words, they wanted it in a justice court to compel me to appeal so that they could attempt to elicit a bond out of me. They need or want a bond based on my faith and credit, but they're attempting to acquire it through bad faith and under an unlawful proceeding. The top protest and or insofar as there is a tax protest and or lien, please see the list of evidence including proof that payment was not accepted after willfully refusing to process it twice. This has happened with other transactions. See evidence regarding letter providing me credit after successful dispute resolution. I contend that there is no lawful application of the above because until this time they've refused to provide the legal proof of who is the owner or information about costs associated with mortgage, property, taxes, condo fees, utilities, or insurance, as well as information